Good morning, everyone. It's Megan Fox. I have been getting far behind in the filings in the Laura Owens v. Clayton Echard case, and I decided I wanted to make a couple of videos where I just read through some of the filings without commentary. So I'm going to start with the motion in limine that was put into the court by Laura Owens' attorney, David Gingras. And I haven't got a chance to read through this yet, so let's read through it together. I'm going to try and keep my commentary to a minimum. I'll discuss on a live stream later. Pursuant to Rule 35A and Rule 65B, Arizona R Family LP, and Rule 404B of the Rules of Evidence, petitioner Laura Owens moves for an order excluding the testimony of three witnesses, Greg Gillespie, Michael Maricini, and Matthew Mulvey. As explained below, these three witnesses should be precluded from testifying at trial in this case for two different reasons. First, it appears respondent intends to call these witnesses for the sole purpose of establishing they had similar experiences with Miss Owens, i.e., each witness may claim Miss Owens faked a pregnancy while in a relationship with them. Thus, if she did that to me, she must have done the same thing to Mr. Echard. Such other wrongs testimony is plainly inadmissible in this case pursuant to Rule 404B of the Arizona Rules of Evidence. Second, each of these witnesses should be precluded from testifying pursuant to Rule 65B1 because Mr. Echard has failed to comply with the disclosure requirements of Rule 49A. In short, Mr. Echard has provided zero disclosure fairly describing the substance of each witness's expected testimony, leaving Miss Owens and undersigned counsel to guess as to what, if anything, each witness intends to say. For that reason, separate and apart from the issue of Rule 404B, none of these witnesses should be allowed to testify at trial. Part 1, Discussion. A. Respondent has failed to timely disclose information required by Rule 49. Taking the easiest issue first, the court should issue an order precluding Mr. Echard from calling Greg Gillespie, Michael Maricini, or Matthew Mulvey on the basis that Mr. Echard has failed to timely disclose these witnesses as required by Rule 49I. The text of that rule is clear. Each party must disclose the names, addresses, and telephone numbers of any witnesses whom the disclosing party expects to call at trial, along with a statement fairly describing the substance of each witness's expected testimony. The purpose of this rule is well settled. The disclosure rules are intended to avoid unfair surprise at trial. See Carlton v. Emhart. Trial by ambush is a tactic no longer countenanced in Arizona courts. Adequate disclosure should fairly expose the facts and issues to be litigated, as well as the witnesses and exhibits to be relied upon. Although this is somewhat flexible standard, disclosures which only outline issues summarily are per se insufficient to satisfy the rule. Finding disclosure statement did not contain sufficient detail to comply with the rule where it simply stated witnesses would testify about all matters referred to in deposition or all matters in the complaint of which the witness has knowledge. Here, the disclosures provided by Mr. Echard concerning the substance of anticipated testimony from Messrs. Gillespie, Maricini, and Mulvey fail to offer any insight into what, if anything, each witness will say. Specifically as to Mr. Mulvey, the entirety of Mr. Echard's disclosure was as follows. This witness is expected to testify about his prior interactions with petitioner, including his personal knowledge about her alleged fabricated pregnancy back in 2014. A single sentence identifying prior interactions with Miss Owens and generally referring to an alleged fabricated pregnancy does nothing to identify the substance of what Mr. Mulvey plans to say about those topics. Based on the lack of any substance to this disclosure, it is entirely possible Mr. Mulvey may appear at trial and say that he initially believed Miss Owens faked being pregnant when she was with him, but he later realized his suspicions was groundless, and he is now 100% certain that Miss Owens was pregnant at the time. Or maybe he will say the exact opposite. Who knows? Because Mr. Echard has failed to disclose anything in terms of the substance of Mr. Mulvey's testimony, Miss Owens has no idea what to actually expect. The same problem exists with respect to both Mr. Maricini and Mr. Gillespie. Contrary to the mandatory duties imposed by Rule 49, Mr. Echard has disclosed literally nothing about the substance of what either of these witnesses intends to say. Given that the trial is barely 40 days away, Mr. Echard's failure to comply with his disclosure obligations is inherently prejudicial and inexcusable, meaning the only appropriate remedy is exclusion. See Zurn by and through Zurn and Ford Motor Company. Affirming exclusion of late disclosed information on the basis untimely disclosure occurred less than 60 days before trial. See Family Law Rule 65B1B, where party fails to timely disclose information, the court may issue order prohibiting the disobedient party from supporting or opposing designated arguments or from introducing designated matters and evidence. Because Mr. Echard has failed to timely disclose information about the substance of these witnesses' testimony, he should be precluded from calling them at trial. B. Evidence of other wrongs is inadmissible. Mr. Echard has made public statements claiming he believes Miss Owens faked pregnancies with one or more prior boyfriends, including the three individuals listed here: Greg Gillespie, Michael Maricini, and Matthew Mulvey. As noted above, Mr. Echard has not formally disclosed anything about the substance of each witness's expected testimony beyond an extremely general suggestion each witness will say something about a past experience with Miss Owens involving an alleged fake pregnancy. This type of other wrongs evidence is inadmissible under Rule 404 of the Arizona Rules of Evidence. That rule provides, except as provided in Rule 404C, evidence of other crimes, wrongs, or acts is not admissible to prove the character of a person in order to show action in conformity therewith. Emphasis added. Rule 404B is simple. It provides when a person is accused of a specific act of wrongdoing in case number 1, it is improper to prove guilt or civil liability by offering evidence the person did something similar in cases 2, 3, or 4. Another case, Ilya v. Pfeiffer, concluding under Rule 404B, character evidence of other wrongs is barred because it has slight probative value and because admission of such evidence gives rise to a strong likelihood of prejudice. Such evidence subtly permits the trier of fact to reward a good man and to punish the bad man because of their respective characters, despite what the evidence in the case shows actually happened. Evidence that one child was given a hard spanking by mother inadmissible under Rule 404B to prove mother injured a different child on a different occasion. Evidence showing party broke the law in the past was explicitly prohibited by Rule 404B to show the same party broke the law on a later occasion. One of the clearest and most analogous examples of how Rule 404B applies in the situation occurred literally days ago when the highest court in the state of New York, the Court of Appeals, reversed the ARP conviction of infamous movie producer Harvey Weinstein. In that case, Weinstein was convicted of SA and ARP as to 3 specific victims, identified as victims A, B, and C. But at trial, the prosecution allowed 3 other women to testify that Weinstein had also ARPed them. The Court of Appeals explained this testimony violated the New York common law rule, which is functionally identical to Arizona's Rule 404B. The general rule is against receiving evidence of another offense. A person cannot be convicted of one offense upon proof that they committed another. People v. Weinstein. The court explained the rule exists to ensure basic fairness. Testimonies from 3 individuals about their own unwanted schmexual encounters with defendant were therefore unnecessary. Instead, the testimony served to persuade the jury that if he had attempted to coerce those 3 witnesses into a non-consensual act, then he did the same to the victims on the dates and under the circumstances as charged. That is pure propensity evidence, and it is inadmissible. Over a century later, we reaffirm that no person accused of illegality may be judged on proof of uncharged crimes that serve only to establish the accused propensity for criminal behavior. At trial, a defendant stands to account for the crimes as charged. Proof of prior crimes and uncharged bad acts are the rare exception to this fundamental rule of criminal law. Of course, Mr. Echard will surely note evidence of other acts may be admitted for some other purpose, such as establishing motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident. But in the unique context of this case, none of those exceptions apply. Evidence showing Miss Owens made a false allegation of pregnancy in the past does nothing to demonstrate her motive, opportunity, intent, preparation, or plan in this case. It doesn't? Really? Because it seems to me like it would show that very clearly, but I'm trying not to comment. This is so because the alleged motive plan here is entirely self explanatory. Mr. Echard believes Miss Owens faked being pregnant as a way of trying to trap him and or to force him into continuing a relationship with her. This theory is obvious on its face without the need for support from other witnesses. It is essentially a purely rhetorical argument that could be made in any similar situation, including in cases where the pregnancy results in the birth of a healthy child. Men who find themselves in Mr. Echard's position have always accused women in Miss Owens' position of lying about being pregnant as a way of gaining leverage. Well, that's because they do. That same classic theme forms the plot lines of countless films, including the 1987 thriller Fatal Attraction, in which Michael Douglas has an extramarital affair with Glenn Close, who later claims she is pregnant before she repeatedly stalks Douglas, kills his family pet bunny by boiling it in a pot, and famously warns,
"I'm not going to be ignored, Dan."
If Mr. Echard believes Miss Owens wanted to trap him, he does not need to call any other witnesses as backup. He can offer that argument based entirely on his own personal beliefs, and the court can either accept it or reject it. Of course, it is undisputed this plan did not work in this case, assuming a plan even existed, which Ms. Owens completely denies. She denies the contract she wrote? The dating contract? Really? The one we have on email? I'm getting exhausted by this case. After their one night together, Mr. Echard flatly refused to have any further romantic relationship with Miss Owens. If Miss Owens' intent was to trap Mr. Echard, that plan was a complete and total failure in every respect. Well, not really, because she trapped him in court for a year now, didn't she? In and of itself, this would strongly negate any suggestion that Miss Owens falsely claimed to be pregnant as some sort of sinister plan. Thus, even if Miss Owens did somehow fake being pregnant in past prior cases, which she denies, that fact would have absolutely no bearing on the issue of whether she was actually pregnant in this case, a point which is supported by objective medical proof, none of which is verifiable. Just saying. These contested stories about past relationships do nothing, at least nothing meaningful, to support the idea Ms. Owens falsely claimed to be pregnant in order to trick or trap Mr. Owens into dating her. Instead, Mr. Echard's intent here is obvious. He wants to offer testimony from one or more of Ms. Owens's past ex-boyfriends to show she lied about being pregnant with them, therefore she probably lied about being pregnant with me. As New York's highest court explained in Weinstein, that's pure propensity evidence and it's inadmissible, and the same is true here. He wants us to see this YouTube clip. And I don't know what it is. Oh my God, he attached a Fatal Attraction clip. I kid you not. Yes, he did. Hold on. Let's get over to the clip and play it. Although I probably will get hit with a copyright. Let's hope not. Let's speed it up. Maybe that will help. Yes, I remember this part.
We met somewhere before.
Uh-huh.
You're a lawyer? Moving to the country? Yeah.
This is the part where he finds her in his house.
Just cut it! I don't know what you're up to, but I'm gonna tell you it's gonna stop right now. Responsibilities! Appointments!
What am I supposed to do? You won't answer my question.
Just,
Why can't we just be like that again?
Okay. So, I can't believe that he attached this.
you tell my wife, I'll kill you.
All right. Let's go back. He actually attached a Fatal Attraction clip to the motion in limine for the judge. I can't believe that. This is why I tell you that footnotes are important, folks. Conclusion. For all the reasons stated above, petitioner moves the court for an order precluding Mr. Echard from calling Greg Gillespie, Michael Maricini, and or Matthew Mulvey as trial witnesses. And I don't think there are any attachments here. Okay. All right. Well, this is problematic for him, though, because he also asked the judge to take judicial notice of Greg Gillespie's case. So hang on, we'll get over to that in just one second. Okay, here we have the request for judicial notice, which was put into the court by David Gingras, aka Douche Canoe Esquire, to support her position. This is a request for judicial notice assigned to the Honorable Julie Mata. This was before his motion in limine, which we just read, to support her position either at trial and or in the future dispositive motions pursuant to Arizona rules. Petitioner Laura Owens respectfully asked the court to take notice of certain records reflected in the table below, because Ms. Owens has supplied the court with the necessary information to support this request. Judicial notice is mandatory, not optional. The court must take judicial notice if a party requests it, and the court is supplied with the necessary information. Judicial notice of these documents is proper because the records all relate to another matter filed in the Maricopa County Superior Court. It is well settled a court may properly take judicial notice of its own records. The court may take judicial notice of court filings as they are matters of public record, and it is also well established that a court can take judicial notice of its own records. Okay, big deal. We get it. Also, to avoid any misunderstanding about what this request means and what the court is being asked to do, Ms. Owens merely asks the court to take notice of a prior proceeding, Owens v. Gillespie. Well, isn't that interesting? In which she was a party. In doing so, the court may take notice of the existence of the allegations in that case and how those allegations were resolved. At the same time, the court is not being asked to find that any of those allegations were true or false, because doing so would be improper. While matters of public record, such as prior court proceedings, are proper subjects of judicial notice, a court may take notice only of the authenticity and existence of a particular order or pleading, not the veracity or validity of its comments. Yes, by all means, Judge, don't look into the truth of the matter of this case, because that would be detrimental to my client. To summarize, Ms. Owens asked the court to take judicial notice of the following points based on the information provided. On August 21st, 2021, Ms. Owens filed a civil action in Maricopa County Superior Court against an individual named Gregory Gillespie. In her complaint, Ms. Owens alleged she and Mr. Gillespie dated briefly. She became pregnant with Mr. Gillespie's child, and after learning of the pregnancy, Mr. Gillespie subsequently used verbal and emotional abuse to coerce Ms. Owens into terminating the pregnancy, which she later did. Mr. Gillespie denied Ms. Owens' claims, and he further alleged Ms. Owens lied about being pregnant. Based on that allegation, Mr. Gillespie asserted counterclaims for fraud and intentional infliction of emotional distress. And by the way, folks, I just want to remind you that this would be the case that we found the Fiverr sonogram. That's right, the Fiverr sonogram that was lifted from a blog of a woman who lost a twin in a vanishing twin incident, which is really sad. And she is now retaining counsel to possibly go after Laura Owens for stealing her photograph. On July 26, both parties filed simultaneous motions for summary judgment. On November 9th, 2023, the court issued a minute order entry granting both motions for summary judgment, thereby terminating the action. The court made no findings as to whether Ms. Owens was telling the truth or lying about her pregnancy. Yeah, because the court was lazy. The court did not find Ms. Owens lied about being pregnant. Yeah, the court just dismissed it and said, "Go away, you're both annoying me." Mr. Gillespie later applied for an award of taxable costs, claiming he was the prevailing party. On February 15th, the court issued a minute entry order denying Mr. Gillespie's request for costs. In that order, the court made a finding that neither party prevailed under the unique circumstances of this case. So neither one won, because the court was too lazy to look at the facts. The court has reviewed Gregory Gillespie's verified statement of costs filed December 15th, where he requests an award of taxable costs in connection with his lodged judgment. The court finds that neither party prevailed under the unique circumstances of the case, and neither party is entitled to taxable costs. All right, so here it is. Here's the filing. All right, so he wants his cake and he wants to eat it too. He wants the judge to take notice of just that particular part of the Gillespie case while at the same time excluding Greg Gillespie's testimony from the current case. It's a bold strategy, Cotton. Think it'll pay off? I don't know. But I would say stay tuned. All right, those are the latest 2 filings I hadn't read and I wanted to put them together. Hope you enjoyed them. I'm sure there will be live streams soon. See ya.